If you think you have to know the law cold in order to pass the bar exam, you're in for a rude surprise when it comes to the test. Stick around and I'll show you what really matters on your bar exam. I'm Jackson Mumey, the owner and founder of Celebration Bar Review, and for the past 25 years I've helped thousands of bar takers, people just like you, to make their next bar exam the last bar exam. If you want to know more about how we do that, check out the links on this page after this video. Well, welcome back to our series on top 10 myths about the bar exam. This particular video, we're in myth number 5, so we're halfway through our countdown, and it's been an interesting opportunity for me to talk about the myths that I see students buy into, much to their detriment, I think, and talking about the myth conceptions, if you will, about what the bar exam might be testing or might not be testing. And I appreciate so much the reaction that I get from our viewers on these YouTube videos. We've got literally hundreds of thousands of views of the overall series, so I know that it's of interest to people. If you've been watching, you know that in our previous videos in the countdown, one of the videos was about gaming the exam. We titled it Fool Me Once. And I talked in that particular discussion about how people try to figure out all of the quirks and the oddities of the test and ways to get around learning specific things in order to pass, in order to game the test. Well, in this week's myth, I guess I'd say we're talking about the opposite problem. It's the I've got to know the law myth. And it's really a pervasive one because it makes sense intuitively to most of us. When we hear the words bar exam, we think, well, that's an exam about the law. The reasoning goes, therefore I ought to know more law, or the more law I know, the better I'll do on the exam. It's a very subtle persuader, but in fact, it's a very destructive myth. Because what this actually fails to recognize is that there's so much more to the bar exam than just being able to know or recite the law. Now, for many years, I used an example in talking about this problem that I'm afraid now is pretty dated for many of you. I used to use a character from a movie called Rain Man with Dustin Hoffman, but I have a feeling most people have never seen it. I do know that over the years on television, there have been a number of characters who've been portrayed as being autistic, but savants, really good at what they did, but no personal skills. I'm thinking about House in the medical field, or Jerry Espenson on an old TV show called Boston Legal. And it seems like every season there's some new series that's got a really brilliant but challenged individual when it comes to dealing with human interactions. And the problem was that in both of those, or all of those fictional accounts, what we see are people who are very smart. They're super smart. They actually have the ability to be able to recite in many cases and remember details in their particular field with specificity that we could probably, most of us, never even hope to obtain. And I think you're all probably familiar with that kind of personality, the savant, the artistic savant, the legal savant, the medical savant, someone who can recite all of the information and rules by heart. And I've actually had the opportunity in the 25 plus years that I've been working with bar students to work with more than a few people who really didn't have a problem knowing the law. They were that kind of brilliant, genius people. They know it, they memorized it sometimes, maybe sometimes they had a photographic memory, sometimes they were just plain that smart. And it all makes sense, and you would think, well, those people for sure passed the exam. But the reality was actually quite the opposite. You see, being able to know and recite the law is not really a prerequisite for success in order to be a lawyer. And if you have any doubt about that, just ask yourself, personally, would you want Dustin Hoffman's Rain Man as your lawyer? I mean, I would like him with me at the blackjack table counting cards, but I don't think I want him representing me in the same way that most of these legal characters that you see on TV and films probably are not people you want representing you, even if they know all the law. What you find is that that kind of individual simply isn't effective because they don't know how to deal with people. They don't know how to see the arguments and the problems in a more nuanced way, and it makes them less effective in the practice of the law. Now, the point I'm trying to make here about the bar exam is that too often what bar takers think that they need to do is to memorize the law. And we've talked about memorization in other videos in this series. It's certainly one of my top destructive myths about how to pass the bar. Simply knowing the law or memorizing it as a prerequisite to passing the exam is a terribly dangerous myth, because what it does is send bar takers off in the wrong direction. Here's the reality. If you think you're going to pass your bar exam by sitting down and reading the law, briefing the cases, learning the law, and the picture that comes to my mind is Abe Lincoln sitting by the log fire, reading his way in preparation for the bar, that would be great if we were in the 1800s or even in the 1970s. But the truth is, it's not the world that we live in today, and it's not the bar exam we live in today. You see, today we're in this very different world in which you can get the law very, very easily. In fact, so here's an interesting experiment. If I ask Google, can you tell me the elements of the torts of negligence, you'll notice that it comes up with all sorts of opportunities to find out exactly what negligence is. That's pretty simple. But I can even go further than that. I can actually go up to Siri. Hey Siri, what's the elements of the torts of negligence? And it comes back to me, and let's see what it says. It's got all of these different websites. If Siri can tell me that, if Google can tell me that, if Alexa can tell me that, if Watson can tell me that, what great value is it for the bar examiners? You see, the bar examiners are not stupid people. They are charged with the task of selecting and helping weed out those people that are not yet actually qualified to practice law. Now, many of those people who are bar examiners might have been academics in some setting, but they are not in the academic world today. That's not what they're there to do, and they're not really looking for the academics so much as they're looking for the practical matter. Now, if that's hard for you to figure out, probably many of you had law professors when you were in school, and you thought to yourselves, wow, this person would be dangerous if they ever got in a courtroom. I had a brilliant first-year torts professor. He had actually come out of Yale Law School with a joint MD, JD degree, and he was, as you might imagine, super, super brilliant. In fact, I think he's now dean of a law school somewhere. But here's the thing. Somebody asked him one day in class, how would you actually use res ipsa loquitur in a lawsuit? And he looked at them and said, I have absolutely no idea. And he opened up his briefcase back in those days. He had this big, huge briefcase, and in it, he had a nutshell. And he opened the nutshell to res ipsa loquitur because he had no idea how it would be used in a courtroom. He knew everything about it. He understood what it meant. He just didn't know how you would use it. You see, just knowing the law wasn't a prerequisite. And by the way, he was not a member of the bar. He never even sat for the bar because he knew that his skill and ability was not what the bar examiners were looking for. Now, the examiners know that in order to practice law, you have to be able to use the law as you understand it. And so, in every jurisdiction, the bar examiners test how you use the law. They do it on the multistate exam, they do it in the essays, they do it in the performance tests. The bar exam is a test of how well you can identify the rules of law and how they get used more than whether or not you can memorize and recite them. Now, I know some of you will say, well, wait a minute, what about the MBE? I mean, isn't that about memorizing the elements? Well, no, not really. The multistate is a test of how well you can make fine line distinctions between one answer that's okay and three that are almost certainly wrong. You see, it's not just knowing the law, because if you had memorized the law in all of the 7 subjects of the multistate, I can assure you that by itself, that's not enough to pass the exam. You have to know how to apply those rules in a quick fashion. You don't have time to recite mnemonics and sing songs to yourself. You have to know how to discard irrelevant information. And you have to be able to make distinctions between 2 answers, for example, that reach the same conclusion, but for different reasons. And that doesn't always turn on the elements or the question of law. Sometimes it's nothing other than a question of the application of the facts to the law, and that's what makes the difference. Now, essays are very clearly a test of how you use the law and not law memorization. They're a test of whether or not you can apply what I call paraphrased rules of law to the facts and the problem that are given to you. Do you have to get the law correct verbatim, word for word, with all the elements to pass an essay exam? And the answer to that is unequivocally no. I've read now literally tens of thousands of answers from every jurisdiction in the country. I've seen answers that got passing scores, and I've seen answers that passed where the law in the essay was dead wrong. Now, I've also seen answers where the law was completely correct, but they still got a failing score. You see, just getting the law right is not the primary thing that the examiners are looking for. And so in a course like ours, we're going to show you how to make the most out of what you know about the law. But imagine how this changes your study strategy if instead of having to know all the law, instead of spending hundreds of hours cramming the law, learning it word for word, you simply have to learn how to use the law that you already know. You leverage what you've already learned. What that would mean is that instead of cramming, or doing flashcards or practicing thousands of questions, instead of driving yourself crazy trying to come up with a mnemonic device, instead of all of that, you start using your common sense. You start asking yourself, well, if I know this rule, how do I apply it? Or what do I think the rule would have to be on both sides of the dispute? And then how would I use it in practice? How can I use the law as I know it to solve this client's problem? If you can answer that question, then you're well on the way to actually knowing and using the law and understanding that use and expressing it to the examiners. And we'll show you in our course how to do that step by step, but I think it's one of the most important things you can do to be successful on the bar. You know, very often I talk to students who are writing essays, and they start reciting sort of this boilerplate language that they've got. I've talked in other places about people that talk about logical relevance before an evidence essay, or maybe in California they feel compelled on every community property essay to define community property. And I ask why you do that, and they say, well, it's what I was told to do in my big box bar review or my big box law school. And I ask them, is it relevant to the problem itself? Does it get us closer to understanding the problem? Is it specific to the problem that's in front of you? Well, no, it's not. It's just stuff I was told I have to memorize and put on every answer. Well, really, you don't have to do that at all. In fact, it tells the examiners that you're not looking at their particular problem. You're just reciting to them. And the truth is, I think that to the examiners, that is really a fearful thought. They don't want you showing up in a courtroom, representing a client, taking up your time, the client's time, opposing counsel's time, the judge's time, the jury's time, talking about things that don't matter. And that's why it's so dangerous to be an issue spotter, knowing the law cold, memorizing and reciting. You see, it all comes together. And so when people get into that process where they start just putting in things because they were told to do it, even if it doesn't matter, then what's happening is that they're heading down the wrong path. They're wasting words, they're wasting time, they're wasting energy, both in the study and in the practice of the exam itself. Now, before I wrap this up, let me be clear, because I know the criticism that comes. Mumey says you don't have to know the law. He's full of it. No, that's not what I'm saying at all. You do need to know some law, but here's the point. You went to law school. You did learn some law, and you graduated from law school. You do know some law, and maybe you've been practicing law for a while. You do know some law, and you're taking a bar review. Hopefully it's ours, and you do know some law. That's what we do in the bar review. All right. But what we also want to do is fine-tune that law you know, narrow it down, show you how to use it, show you how to make it apply to the problem. And that's the real key of a good bar exam. It's not putting all of that information into your brain so that it just spills out over the 2 or 3 days of a bar exam in some mindless Rain Man patter. And I know that for some of you, that's very disappointing. Some of you really wish that's all this exam was about. And the problem is that there is a title for people who take that approach. You're not going to like it, but the title is called a bar exam repeater. You see, the people that do that just blurt out rule after rule after rule, pass very rarely. They fail most of the time. And they really work hard. They did everything they thought they were supposed to do, and they keep failing the exam, and it goes on and on. The cycle continues itself. What these people don't understand is that the skill of discernment, the skill of being able to apply what you know, is every bit as important, if not more important, than simply knowing the law itself. Now, I know that's a tough message to hear, and I hope that you take it to heart. I hope you think about it. Remember, I'm not saying you don't need to know the law. I'm just saying you don't need to know as much law as you think, and you don't need to know it in a way that allows you to memorize and recite it. If you're curious about how that works in practice, I invite you to check out our course. I think you'll be really surprised at what you can do and how efficiently you can do it, and why this myth then won't be one that derails you from success on the bar exam. Well, thanks for being with me today. We'll be back with the next message in our series soon.